Okay, let's now bring in, just to unpack a bit more of this very technical procedural talk that we had this morning from Judge Piet Koen. It's always a pleasure to speak to a legal mind on this, someone who can help me understand how this works. Tyrone Maseko, legal expert, regular guest here on eNCA. Hello to you, Tyrone. I thought this might be a good time for you and I just to unpack for viewers this morning who don't quite understand why there has been another delay. There seems to be a procedural concern around a plea. Can you speak, Gareth, to me and just help me understand what actually has caused this next delay?
Yeah. Hi, Gareth. So simply put, ordinarily how it would have worked today, so forget for the moment this Section 105 argument, 106 argument, but ordinarily how it would work is that at the beginning of a trial, you've got what we refer to as a plea process. So that's where the indictment is put to the accused, told exactly what charges he's facing, and once all of that is read by the prosecution into the record, the accused then gets a chance to plead guilty or not guilty to the charges. And then the evidence then ensues, assuming that they plead not guilty. The state then has to present evidence to prove its case. That's the normal course. Now, what's happened here, and for all intents and purposes, that's what should have happened here, except that in Section 106, 1H, I know it's quite technical, of the Criminal Procedure Act, provides that one more plea is possible, and this plea is a technical one, and simply what it says is that one can challenge the standing of the prosecutor who's prosecuting the matter. So before I can even be prosecuted, you need to show and convince me that actually you are a prosecutor in good standing, and so because there are requirements as to prosecutors appearing in court, you got to have the right standing, just as they do to us. You got to be a member of the bar, the law, the LPC, and the like, and you got to combine all those things. So the short of it is that can be challenging. That is a plea that one can plead formally. Say, no, I'm not convinced that you have a standing to prosecute me. So just provide me with the necessary documents that show that you've been authorized by the National Director of Public Prosecutions. What's interesting in this case is that we're not sure yet exactly which aspect the defense is attacking. I mean, there could be a myriad of things. Could very well be that ultimately they'll argue that, well, you've got no formal standing because you're no longer a prosecutor. Remember, and I raised this in passing, but it's just something that came to my mind when I was watching the screen earlier, that I seem to recall about a year or two ago reading somewhere, I can't remember where now, that Billy Downer effectively had, well, his time to retire had come. So I'm not sure what his status is, whether he's actually retired. And I remember that when I was reading that article towards the end, it seemed that he was holding his retirement in abeyance just so that he could complete this matter, because this is a project that started a long time ago. So now I'm speculating, but I remember reading something like that. Could very well be that this application that they intend to bring has got nothing to do with that. But that is something that just stuck with me at that time. That's quite interesting, that he's ready to retire. And I interviewed him and said that I'm ready to retire and go away and go live somewhere in some fancy place there by the creek. But I've got to finish this first. So it could be related to that, I'm not sure. Other than that, I cannot see what else could be, Gareth, because everything else is formal. If he's not an advocate, we'd know that he's no longer an advocate. If he's been struck off the roll for whatever reason, that would be apparent to everyone, not least the NPA. Certificates issued by the National Director of Public Prosecutions, those are formalities. They do these things all the time. In fact, we don't even bother challenging these things generally when we appear in court, because you take it as a given. So they must know something that we don't. I'm not sure at this point, because the application has not been brought yet. We'll know when the application, they refer to these founding affidavits. So when we say application, we're referring to the founding affidavit that they were talking about in court, which now have to be exchanged so that spill it down and the prosecution know exactly what it is that Masuku and co are contending, insofar as alleging that he doesn't have standing to prosecute Mr. Zuma.